And here we go. The case officially begins. State of Texas v. LaDonna Renee Lewis. Notice how the judge jumps straight into the indictment. No fluff, just facts. This is common in arraignments where the focus is on charges and possible penalties.
And you are here with your attorney, Mr. Nayland, and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary? In summary, this indictment alleges that on or about November 8th, 2020, is that a three? Yeah, 2023. 2023 in Jefferson County, Texas, you committed the third-degree felony of misapplication of fiduciary or financial property of an amount more than $30,000 but less than $150,000. Do you understand what you're charged with?
Yes, sir.
If convicted of a third-degree felony, you face a
Balance scale, let's pause here. Misapplication of fiduciary property may sound fancy, but in plain English, it's basically mishandling or misusing money that wasn't yours to play with. And with a range of $30,000 to $150,000, that's no small amount. Question for you. If someone stole your money but promised to pay it back slowly, would probation feel like justice?
term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
Punishment range. The way we're getting all this changed, when you touch the pad with your hand, it makes marks on it. That's why I have to. I don't know what has happened to all these things. They didn't used to do this, and now they're acting odd. An agreement's been reached.
You're just going, there's restitution, and then we're going to ask you to decide whether it's straight or deferred in the terms.
Okay. The agreement is she would be placed on probation.
Yes, sir. There's just no blank check that says just probation.
Okay, we need, because the way this reads, there's no consideration moving to make a contract here. This just says restitution, court to determine type of probation. Let's see.
Because one says deferred, one says after conviction placed on probation. There's no one that says court to determine type and length.
Lightbulb, here's the twist. The state isn't fighting for hard prison time, just probation. But the judge has to decide. Will it be deferred probation, which leaves no conviction if completed, or straight probation, which still counts as a felony? That difference could change LaDonna's future forever.
All right, I've got the agreement is probation to be determined by the court. Restitution will be paid in the amount of $8,966.09. And then under just court to determine time, but it's under non-binding, but that's, let me change that. We're talking about community supervision here, right?
Yes, sir.
Okay. And it's up to the judge to decide how many years? Is that what I'm going to do?
It's, whether or not it's a deferred or a straight probation and the terms, judge.
Okay. So what I think I'm going to do, there's really no non-binding recommendation being made, is there? This is all.
Correct. It's just, this is just.
Okay. So I'm going to take the following binding We'll check out community supervision. Did y'all agree on a term of years on probation, or is that my call?
That's your call, Judge.
Oh, okay. I'm going to put up to 10 is what.
Yes, sir.
Okay, is that your understanding of the plan?
Yes, sir.
If I follow this agreement of probation, deferred or regular probation, and order restitution, and this can be up to 10 years in length, it's the court's call, but whatever term of probation the court assesses, it can be shortened to 1/3 if you do well and complete probation. So 10 gets you 3 1/3
Yes, sir.
if you do well. You're going to do well.
Absolutely.
If I follow this agreement, you have no right of appeal.
Clapperboard, did you catch that? A 10-year probation could shrink down to just over 3 years with good behavior. That's a huge incentive. Imagine being told, stay out of trouble, and you get your freedom back 7 years early. Would you take that deal?
Of your case, do you understand?
Yes, sir.
How do you plead to this, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir.
I'm going to show you what's marked as State's Exhibit 1 here. So you sign that document, understand it, discuss it with your attorney, are the contents true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No
And
objection.
without objection. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with? The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God. State's Exhibit 1 is made a part of the record for all purposes. I think we need a pre-sentence report. So everybody can then sound in, and because deferred, regular probation, one's got a conviction, one's not, and it depends on factors and circumstances that
Yes,
I don't know about.
Yes, sir.
Yeah, okay. What we'll do is we're going to order a pre-sentence report. You will touch base with the
Bookmark tabs, this is standard procedure. Before sentencing, a probation officer interviews the defendant, digs into their background, and prepares a full report. Think of it like a legal report card that helps the judge decide whether someone deserves leniency or not.
probation officer here in a minute, and you will come, they will interview you, and they will make a report. We will return back on.
We're going to tentatively set for September the 26th, Judge.
September 26th.
Everything.
Commissioner Bone?
Yeah. All right, let me draw my underwear.
Maybe that chair left.
That's good.
I called and shot it away a little bit.
Select.
You said September 26th?
Another Friday.
Yeah, I get up. I'm not sure I gotta be in Tampa on this that case that week, but it's the beginning of the week.
So that's good?
Yeah, it's good.
Okay.
All right, we will return, then you will get a copy here. And then all parties can add any additional information you want me to consider, and the court will be fair.
Yes, sir.
And this is all fixable. And look, when it comes to restitution, you pay the restitution back, you're going to get rewarded.
Judge, out of what she's taken, she's already paid back over $25,000 of the restitution that she
You
owes.
pay it
So the remaining.
complete, and the quicker you do it, the more happy I am about taking care of this, because the people aren't getting interest on it. They've lost. They're not getting interest, which isn't. I think that's unfair, actually. But the quicker you get them paid back, the quicker they can use the money that was lost, and that you get rewarded for that. Okay, just a little word to the wise. But restitution is a key part of this case. Okay. Awesome.
Thank you.
Thank you.
Studio microphone, VO6. Thaw balloon, and there it is. The judge makes it crystal clear. Pay the money back, and you'll be rewarded. This case isn't just about punishment, it's about restitution. making victims whole again. But here's the bigger question. Should justice be about repayment or consequences? Let me know what you think.